Ladies and gentlemen, thank you to the Inspector General for Personal Data Protection, the Cardinal Stefan Wyszyński, University of Warsaw, Opole University and the University of Szczecin for their kind invitation to address a few words to you. I'm sorry that due to other commitments I'm unable to be with you in person. I see that you have a very full and ambitious agenda today, and I would like to only highlight three aspects of the question of data protection by churches and other religious organizations. First, on the need to assume that churches are by default within the scope of EU data protection rules. Second, on the need for precise and clear laws with foreseeable effects for the individual. And third, on the need for an independent supervisory authority to oversee and to enforce all personal data processing. I represent an independent institution of the European Union. We are responsible for ensuring compliance of the European Union bodies with data protection rules. We have also a remit of advising the EU legislators on all matters affecting fundamental rights, in particular the rights to privacy and to data protection. Together with the assistant EDPS Wojciech, our vision is for the European Union to lead by example. We want the European Union to develop a new approach to data protection, which holds true to data protection principles at the same time as embracing the benefits of technology. This means less prescriptive rules. We want all controllers, including religious organizations, to take responsibility for the details of compliance. The guiding principles are accountability and openness. And openness means telling individuals what is happening to their data and allowing them to take more control over it. That is why personal data processing by churches and religious organizations is relevant. This conference is right to take this important issue. It is particularly important because of the data in question. Under European Union law, data which reveals religious and philosophical beliefs is an example of sensitive data, and processing of such data is in general prohibited, subject to certain exemptions of direct relevance to the Church. And this is recognized in the newly agreed General Data Protection Regulation. In a minor innovation compared with the existing Directive 95/46, the new regulation in Article 85 will contain a specific provision on data protection rules of churches and religious associations. I know that this is a hotly debated topic in Poland. Religious organizations, and not only the Catholic Church, find themselves under more public scrutiny than ever. Churches are accountable for how they handle sensitive personal information, including information about children or vulnerable members of society. And indeed, this is an issue which touches several core values of the European Union. Article 10 of the Charter of Fundamental Rights of the EU affirms the freedom of thought, conscience and religion, including the freedom to change religion or belief and to practice alone and in community with others. The rights to privacy and to the protection of personal data are included in the same section in the Charter as Article 10. The right to data protection is, of course, formulated in a considerable detail. It includes the right for data concerning an individual to be processed fairly, for specific reasons, and on the basis of the consent of the persons concerned or some other legitimate basis laid down by law. The right also gives individuals the right to access data collected about him or her and to have it rectified, and the right requires the rules to be subject to control by an independent authority. These fundamental principles are valid for the Church and all religious organizations, and they have been expanded into the detailed rules of the incoming regulation. Moreover, the Treaty on the Functioning of the European Union, commonly known as the Lisbon Treaty, also juxtaposes data protection and the status of churches. in Article 16 of the treaty, the EU committed itself to passing laws on data protection. Then Article 17 affirms the EU's respect for the status of churches under national law. So, Recital 120/18 and Article 85 of the draft regulation now echo the treaty in respecting and refusing to prejudice existing national laws on churches and religious associations or communities. We should also be clear that the rights in the Charter to privacy and to data protection, like the right to privacy in Article 8 of the European Convention on Human Rights, apply to the individual rather than the collective. How then to avoid conflict between norms in European law and in church law? First and foremost, there is no specific European Union norm which excludes religious organizations from data protection law. And we must assume that any person or organization that is responsible for the processing of personal information is within the scope of the European Union's rules on data protection, unless one or more limited exception applies, like processing for purely personal or household purposes. It clearly flows from both Articles 8 and 10 of the Charter that the individual must be free to consent to processing of data and to withdraw that consent. In the same way, he or she must be free to choose to practice a religion or to hold a belief and to change it, or to renounce it altogether. And moreover, churches are obviously involved in the processing of sensitive data which reveals individuals' religious belief. The new regulation will maintain the existing exemption which allows churches and other bodies with a religious aim to process sensitive data in the course of its legitimate activities with appropriate safeguards, on condition that the processing relates solely to the members or to the former members of a body or to the person who have regular contact with it in connection with its purposes. And finally, on the condition that the data are not disclosed outside the body without the consent of the data subject. So, data processing can only be lawful if such conditions are met, or if other exemptions are satisfied, such as the individual having given his or explicit consent to the processing. There is a specific provision for churches, but the reach of this provision is limited. Article 85 of the draft regulation allows existing comprehensive data protection rules for churches to continue to apply, but they may apply only on condition that they are amended to be consistent with the same regulation. So by implication, if, and at the time of the regulation's entry into force, a member state does not have any such comprehensive rules for church data processing, we should assume the regulation will apply in its entirety. And secondly, specific public laws on personal data processing by the church must be precise and clear. Case law on human rights in both the Court of Justice of the EU and the European Court of Human Rights in Strasbourg consistently underline the need for foreseeability. Where there is a difference between the rules in the new regulation and national approaches as regard processing by churches, then those differences should be clearly set out in the law, that is to be precise in public law. So citizens must be able to predict the effect of the law, especially where the law may interfere with their fundamental rights. Finally, data processing must always be subject to independent oversight and enforcement. Like Article 8 of the Charter, the new regulation will specifically require an independent supervisory authority to oversee the processing of personal data by the Church. This authority does not necessarily have to be the national data protection authority, like the GIODO, but the authority must conform to all the regulations prescriptions for a national DPA in terms of independence, competence, tasks and power. So it's worth repeating, this authority must be independent and be competent to carry out the tasks of a data protection authority. Let me conclude with few anecdotes. First of all, I have had 4 priests in my family, 2 uncles, 1 uncle by marriage and 1 cousin, so it is fair to say that I'm not stranger to the church. Second, I think I was the first data protection regulator in the EU to deal with today's issue. So it would be useful to share very briefly my experience with you. I drafted in the 90s a Data Protection Act on behalf of the Italian government. And years later, when this Data Protection Act had been fully implemented, the Church asked for legislative changes. But it was too late, and the government was not entitled by law to do it. The outcome of the dialogue I had the honor to contribute to as Secretary General of the Italian Garante was the adoption of only 1 legislative provision to reinforce the Church's accountability with regard to purely internal processing of personal data of their members as an alternative requirement to consent, in line with Article 8 of the existing Directive 95/46. And this scenario has been the platform for many decisions adopted by the Italian DPA, with particular regard to complaints demanding deletion of personal data on their baptism certificate. The conclusion has been that these certificates cannot be destroyed since they document a fact, the baptism, that cannot be eliminated, though they can be annotated to register the decision of the data subject no longer to be a member of the Church. Other experiences were related in particular to the borderline between for-profit and not-for-profit activities by religious organizations. I cannot go deeper because of the time constraints, but I would like to encourage a proactive approach from the Church which helps identify appropriate solutions without pushing for shortcuts to escape from the legal obligations. And the 1285/1999 General Decree introduced by the Italian Episcopal Conference in connection with the right to the intimate sphere enshrined in the Article 220 of the Canonic Code has confirmed such a positive trend, as well as more recently the lack of any lobbying by the Church to be excluded from the scope of application of the incoming regulation. Ladies and gentlemen, I'm sure that your discussions today will help illuminate this area, not just in terms of the national debate in Poland, for Europe and beyond. So I look forward to hearing the outcome of today's event, and I really wish you a successful conference. Thank you for your attention.